On the prairies, we have a bit of a unique situation. And in Alberta, Saskatchewan, and Manitoba, any First Nation person with a status card can hunt anywhere on unoccupied Crown lands for subsistence without further proof. So if they encounter a wildlife official, the wildlife official never says, "Sir, are you hunting in your traditional lands? Can you prove that to me? Have you kept up your connection with the community? Has your community been a cohesive unit through history?" At least I've never heard any such stories. I invite anyone, if there's such an inquiry, I want to know. I think that's a real issue, because again, we're talking about people, and if the Métis are going to have real rights, real hunting rights, that means real enforceable, real practical rights, because our people don't want to go to court every time they're charged with hunting out of season. So we have to accept the limitations of findings of common law Aboriginal rights. As we know, there are hundreds of different Métis communities. Are we going to have a test case on every single community? Are we going to spend all the resources to have expert witnesses and anthropologists talk about the culture and the history of all the people? On the prairies, the reason for the enforcement policy on First Nations is that in 1930 the Natural Resource Transfer Agreement was signed, which transferred the ownership of the resources, minerals, and so on, the lands, from the federal government to the provincial government. And in doing so, the federal government wanted to wash its hands of its legal obligations to the Aboriginal people that it had entered into treaties and so on. And so part of the deal was that in accepting ownership of the lands, the province had to promise to the federal government that it would reserve for the Indians the right to hunt for subsistence at all seasons. So this provision applies only on the prairies and doesn't apply in Ontario, Quebec, and Maritimes or the territories. So that's another source of First Nation rights. I don't want to get too far into it, but First Nation rights on the prairies also comes from many different sources: common law, from treaties, and from the NRTA, the Natural Resource Transfer Agreement. But it's the rights are greater geographically, and it's a simpler task to deal with the NRTA. Given the practical limitations, Ernie, Blais, and I got together and talked about it, and we figured, well, the Métis shouldn't be second-class citizens. If it's okay for a First Nation person to just have their status card, and that's good enough, then the Métis should also have that that ability, that if they can show to the satisfaction of the wildlife officials that they are in fact genuinely a Métis person, then they too should have the benefit of the Natural Resource Transfer Agreement. So that was the impetus for the case. He was the political leader at the Manitoba Métis Federation at the time. He was responsible to the Métis. The people wanted answers. The hunters wanted to know, can I go and hunt? So with the uncertainty again of the different communities and the legal tests on common law, we decided to try to prove in the courts that the Métis are constitutional Indians and have the benefit of the NRTA. So the practical result is that it would a win under that legal source would be a real world win, and would result with meat on the table. So that's a real benefit that can be had unfortunately, that source doesn't extend beyond the boundaries of the prairies, but, now, so here we have the concept of a constitutional Indian. Most people, when they hear the word Indian, think of an Indian as defined under the Indian Act, which is a piece of federal, legislation. The term Indian in federal legislation is a defined term. It goes on for many paragraphs and is very technical. The term Indian was never defined in the Constitution. It never was. It appeared under the BNA Act, under the Division of Powers Clause, Section 9124, and it appeared in the Natural Resource Transfer Agreement in 1930, and it appears in 1982. So the arguments in the Blais case, which I have summarized in the paper, it's about 12 pages long, and so with the shortage of time, I don't want to go really in depth, but I just want to touch on it briefly. That the basis for the argument is that, and what the issue is really, similar to what Jean Thayer said, like the issue of the court. We didn't go to court and ask for a reference on defining the Métis or anything like that. The issue is Mr. Blais, by virtue of being Métis, as a Métis person, does Ernie Blais fall within the definition of the 1930 Constitution or the NRTA? So the court doesn't have to look at the boundaries of the identity of the Métis, all those thorny issues that exist out there. But on the facts of this particular case, on the facts of Ernie Blais himself, with on his mother's side, his family's from the historic Métis community of St. Laurent, where some famous people come from. So that's the issue.